Good afternoon, everyone. Thank you for joining us. I'm Patricia Alba, Assistant Director of Communications and Work Life at UFHR. Today we have preferred legal attorneys Elizabeth Kominsky and Brian Samuels. They will discuss the different legal documents that a caregiver should have in place. As Elizabeth goes through the information, please type your questions in the chat. I've also shared a Word file that has a breakdown of the information that will be covered. You can download it and make notes as needed during the presentation. Elizabeth and Brian will answer the questions at the end of their presentation. So with that said, Elizabeth and Brian, the floor is yours.
Great. Thank you, Patricia. Thank you for the introduction. We're so honored and privileged to be here today to represent Preferred Legal Plan and help along with this caregiver support workshop. I am a fellow alumni of University of Florida, so go Gators. And I am happy to be here to go through some of the information that I believe would be super helpful for you and for your families as you take on that caregiver role. As Patricia also mentioned, I have with me CEO and Vice President of Preferred Legal, Brian Samuels, who will be assisting and answering questions as well towards the end of the presentation. So as my job as an estate planning attorney, I get the questions all the time. When do I do these documents? How do I begin? I'm nervous. How do I make sure that I have what I need when the time comes to care for my loved ones? And so my job is to make sure that these haunting situations, these troublesome scenarios don't happen to you. And so the time to do these documents is now. The minute you think about it, the time that you are of sound mind, that you begin the process, that you have elderly parents or siblings that you foresee having to take care of, now's the time to do them. Because doing them now when the person is of sound mind is going to alleviate a lot of pressure for you as the caregiver, and it is going to go a lot smoother. And these documents allow that individual, while they are of sound mind, to elect who they want, what they want. And that makes it easier long-term for you. So, and the busiest time for me, as I'm sure you can imagine, is during the December, January time when it's New Year's resolutions. People want to get this done. So if you do have this plan, or if you're interested in getting these documents done, please reach out to me, because now is the time that I can walk you through, guide you, and give you all the information that is necessary. So what documents do you need? The main documents I'm going to go through with you today are the durable powers of attorney, the healthcare surrogates, and the living wills. I'm sure many of you have been to doctor's offices or a bank or any type of financial institution, and the first thing that they ask you for is that power of attorney. And the purpose of this form is exactly what they're asking you for, is that who do you want to take care of your financials, your business matters, who you want to make those decisions. And these documents remain in effect even if one is incapacitated. So that durable power of attorney allows that individual to list whether it be a spouse, a sibling, a child, as long as they're over 18, they are able to be listed as the decision maker for that durable power of attorney. And once you present that form, you are eligible to speak on that individual's behalf for that broad range of legal and financial matters. Similar to the durable power of attorney, the healthcare surrogate also allows you to elect both a primary and an alternate person to make your decisions. This is upon your incapacitation. And that incapacitation can be anything from a cognitive impairment, it could be Alzheimer's or dementia or any type of mental illness, intellectual and developmental abnormalities, or it can even be while you're unconscious during a surgery. This will allow the individual to act on your behalf, to speak on your behalf, to manage your medical care on your behalf. That is where this document comes into effect. And where I have seen it come most necessary is in the last scenario when someone is unconscious during a surgery. They go in for a heart procedure, but while they're doing that, they see something in your lungs, Well, you're unconscious. You can't say it's okay. So who do they turn to? And that's where this healthcare surrogate documentation would come into effect. So again, this is something you want to do while the person is of sound mind, is able to make these decisions, is able to elect that individual. And that is where this document is able to be used to its utmost potential. The next document is called the living will. This is something that officially states your wishes to not be kept alive by artificial means. And this document became most popular probably in the late 90s, early 2000s in the Terry Schiavo case. And I'm sure many of you are familiar with that. It was here in Florida, where she was kept in an irreversible vegetative state for almost like 9 years or so. And there was a big court fight over who would make the decision between her husband and her family on who would determine whether she was to be kept alive by these artificial means through these machines. So this is where this living will comes up. People come to me all the time confusing that with some other documents. So this is specifically for the artificial means by the machine. This is what they call the pull the plug document. Again, you should elect both a primary and a secondary individual that you trust to make these decisions along with the doctor for you. The next thing I want to mention is a do not resuscitate document, known as a DNR. This document is usually I recommend towards the end of life, an extremely advanced age. And the reason that I recommend it at that point is because this is where you let medical professionals know that you do not want even something as simple as CPR. And as many of you know, that is something that if you go into cardiac arrest or stop breathing, the CPR measures could in fact save your life, and it could give you even a prolonged life. So it's just not something that I do recommend until you're a lot older. And it is very, very different, as you can tell from the living will, which is when you're already hooked up to the machines and you are in that vegetative state, as I mentioned. So now that you have these documents, now that they're in place, how do you use them and what do you do with them? So once you have them, they are effective. They do not expire. Unless you wanted to change the individuals you list, you are able to use them for the financial and for the medical reasons that I mentioned prior. So you just keep them in a safe place. And once they want to be utilized, you pull them out and you use them as needed. So what happens if you didn't do this? Because this is something I get calls about all the time. My mother has dementia. My father had a stroke. I need to make the decisions for them, but now they cannot sign. They're not of sound mind. And this is where it becomes tricky. During this process as a caregiver, at that point when your loved ones are unable to sign these documents and are not able to know what they are signing, at that point you have to go through the courts. The minute I mention courts, I'm sure many of you, your little light bulbs go up and they're like, okay, well, that costs money, that takes time, and it also requires an attorney. And this whole process is known as guardianship. This is something that you could have easily gained through those other documents, but you need the courts now to give you access to make decisions through the formal process of the courts for the guardianship of your loved ones. So again, making sure you do all of the documents at the front end will avoid the guardianship proceedings at the back end. And once you have these documents in place or the guardianship in place, that's where you now have to make the tough decision about what to do as the caregiver for the actual care of your loved ones. And so it's a tough decision. You know, I get asked all the time, what's best for me? And I guess the main answer is, what is the type of care that is needed and the amount of funding that you have to provide for this care. So the first option is the one that you can stay at home. You have your loved ones stay at home where they have a private agency come in, or a nursing agency sends a nurse to do vitals, to give medications in the privacy of your loved one's home. The next one is the assisted living facility. That is something that's referred to as an ALF. And there's also a skilled nursing facility. The main difference between those you'll see there in the documentation, but I'll go through it. The assisted living is a two-prong fee. The two-prong fee, there is a medical side and there is a hotel side, whereas the skilled nursing is a straight medical fee. And the reason that's important is because when I get into how things are paid, Medicaid only pays for the medical side. They do not pay for the hotel side of that specific care. And now that I brought up the Medicaid, it's very different than Medicare. Medicare is what you get at retirement age that you're entitled to because you've worked. Whereas Medicaid, you need to apply for and qualify for. And in order to qualify for Medicaid, you can't really have many assets, meaning that the total of your assets in your checking, in your savings, in any of those accounts has to be less than $3,000. The $3,000, though, excludes your homestead, which is your primary residence. So if you did have your primary residence, it's not like they would calculate that into qualifying for the assistance from the government Medicaid assistance program. The other way people pay for this care is through long-term care insurance. I believe Patricia did mention that there's going to be another meeting about that. So that is something that you would have to have prior to needing that type of care, where you purchase a policy that can fund and provide for the care when needed. This is expensive. It is something that is based, the payments are usually based at the age that you take out the policy. So the younger you are, the cheaper the policy. So if it is something that you're thinking of doing, that you're thinking that you might need because you may not qualify for some other benefits, that might be something you may want to look into the younger that you are, because the premiums are going to be less. So that's kind of what I would describe as what you would need initially for being a caregiver. It's those few documents that I mentioned and how you can utilize them. But even with that, what we really want to also discuss is what happens when that person passes, when they die, what happens to their assets? How can you manage that as well? It sounds like a lot, and that's why I'm here to kind of guide you and make the process as simple as possible. And I think that if you can speak with your loved ones and just find out who they would want to take on these roles, both primary and secondary, you are already ahead of the game. Because I don't need socials or birthdays or anything of that nature to do these documents. As long as they know who they want to elect for these roles, then we can create these documents pretty easily and straightforward for them. Now, for when they pass, I get asked a lot about, I don't have much assets. I'm not a millionaire. Do I need these documents? And I can tell you that most of the time the answer is yes, because of the fact that you want to make sure that you avoid court process for your loved ones, which is known as probate, and that you also have things set up so that it's easy, so that it's straightforward, so that your loved ones don't have to go through any loopholes to receive the assets and the earnings that you've worked hard for. So the best and easiest way to do this is to make sure that you do have beneficiaries on any and all accounts. That goes for your life insurances, your pensions, your 401ks, even something as simple as your checking and your savings accounts at the bank. They're not required to tell you to add a beneficiary when you set up the account. So people always forget those. So make sure you go back to your checking and savings accounts and make sure that there are beneficiary designations on those. Again, you can list primary and contingent for those beneficiary accounts, and all of those will supersede the will, goes automatically. So the first thing I want to speak about is the last will and testament. This document is created during the person's lifetime and allows you to express any wishes that you might have. It can be something as simple as your designation for your pets, for your children, who would be the guardian of your minor children if you were to pass. Even something as memorial wishes. I had one client that what she wanted to do was have everybody come to the memorial dressed in pink and hand out champagne. Something like that is something that you might have a wish for. So we want to make sure that it's in writing and that it's clear as to what those wishes are, and they are there in black and white in that will. All of these documents do have to be signed here in Florida in front of 2 witnesses and a notary. So it is something, again, that we want to make sure that it's done with time when you are of sound mind and you are able to get these documents executed in the proper fashion. The next document is the revocable living trust. I hear all the time that financial advisors recommend doing a trust. Again, it depends on your specific scenario. When you and I meet through the preferred legal plan, I go through a whole list of documentation that would be necessary to produce these documents. And I'll let you know what will be best for your scenario. But this revocable trust, again, is created during your lifetime. It's similar to the last will and testament, and its main purpose is also to avoid probate. Now, we spoke about the accounts and we spoke about designating beneficiaries on those. But what we didn't talk about was if someone owns real estate. And here in Florida, we're lucky enough to have what's called a life estate or ladybird deed. It's available only in certain states, and Florida happens to be one of them. And this document allows you to have complete control of the property for your lifetime. But when you pass, the property would then transfer to your beneficiaries and avoid probate. So you could sell it, you could rent it, you could mortgage it, but it guarantees that it reverts to your loved ones when you're gone. And then all they would have to do is go to the property appraiser's office, the death certificate, and the property would be able to transfer to them without that lengthy court process. So that would be kind of what I would recommend in a nutshell. All of this is modifiable at any point in time. So if you wanted to change things, you're able to do so. You're able to change your wishes. You're able to change your beneficiary designations. Which is also really important. I'll tell you one last story before I go. So we had a client who was divorced. Her ex-husband had just passed, and he forgot to change his beneficiary. He was remarried, and many, many years later, when he passed, she was still the beneficiary. So the ex-wife ended up getting the life insurance policy from her ex-husband. Lucky her, but really unfortunate for his new spouse. So updating these documents is definitely something that's super, super important. We want to make sure we get these done. And like I mentioned, now is the time to do them. Now is the time to reach out. The consult, I make them very easy. I make them very smooth. I make it very easy for you to tell me your wishes and for me then to put them there in writing for you. We're going to now open it up to questions that you might have. I know I saw a few things pop up there in the chat of some questions that you might have. So we're going to run through some of those. I believe, Patricia, do you want us to read them off, or how do you want to handle those?
Yeah, so I've been curating them as they come along. So let's start with the first one that came through. If you have a mentally developed 35-year-old child, are both the durable power of attorney and guardianship required?
I could take that, Liz. So it's kind of one or the other with power of attorney versus guardianship. So if the person, in this case, your 35-year-old child, is of sound mind, as Liz had mentioned, to be able to sign a legal document, then you're going to do the power of attorney. The guardianship, because it's such a formal process through the courts that requires a formal attorney and is expensive, is a last resort. So we always want to try to have the person sign the power of attorney, the healthcare docs, these decision-making docs, which essentially give you the same authority that the guardianship would. So if you're talking about a special needs adult child that cannot sign a legal document because of the incapacity, then yes, you would do a guardianship. And in that regard, I'll point out that there is like a special little case of guardianship for guardianship of an adult disabled child. So it's kind of a little carve out that's a little easier. than a full-blown guardianship, of an elderly person or something like this. So that would be the deal with your adult child, if they're disabled, depending on if they're disabled or not.
Okay, so before we move with the question, I just want to make a note that if Prefer Legal is a supplemental plan that UF offers, and you can enroll for it during open enrollment through my UFL. And I'm gonna drop the link in the chat to the PDF that gives you more information about the plan itself. Okay, so before I do that, the next question would be, can grandchildren apply for and be granted power of attorneys on behalf of grandparents?
As long as they're 18 years old, sure. You can name whomever you want as your power of attorney. There is no priority order. If you don't like your parents, you don't have to pick them. You could pick a sibling. We do recommend a loved one, but a close friend, any of the above. As long as they're 18 years old and can do the job, they can be appointed in the document.
The documents that were mentioned, do they have to be notarized? Or I guess what's the process of making them legal?
Pretty much everything has to be witnessed with two witnesses and also notarized, with the only exception being the healthcare doc. In the statute, it doesn't require a notary for the healthcare doc, just the two witnesses. But we usually notarize those anyway, but that's the answer. They all have to be notarized except that one.
Do last will and testaments have to be processed through probate?
This is a great question by Monroe. Yes, is the answer. So let's be very clear on this. You do your will, you map out all your wishes, to the nth degree, you've named your point people, you've signed it, witnessed, notarized, it's done and done, it's good to go. Still has to be probated when the time comes. It's a little bit of a misnomer out there. People think that, oh, I did my will, I'm good. No, it's still going to have to be probated, which, by the way, is what happens with, 80% of a state. A lot of people go through probate. That is the standard. Probate also is not a nightmare in the state of Florida. In other states, it is. In California, for example, it's 15 to 20 grand to do a probate after you're gone for your loved ones. Here in Florida, somewhere in the $5 grand-ish kind of range, 5, 6. So not as bad, but probate is that cost. It takes months, not weeks, to do probate. It gives an opportunity for creditors to come in and make claims and get paid out of the estate. You can avoid that whole ball of wax with either of the techniques that Liz had mentioned, which is the trust planning, or what we personally prefer is the ladybird deed planning. And again, it just requires a little bit of being proactive with it to put this stuff in place ahead of time. And we always say it doesn't make much difference to you because you'll be gone, but your kids will say, or your loved ones will say, oh my God, they set this up for us. Like, we don't have to do anything. This is amazing. That's where the benefit comes in with the avoiding probate. But yeah, remember that just because you have a will doesn't mean you're avoiding probate.
If you are a single parent and want to leave everything to your children, but they are younger than 18, would it be wise to list them as beneficiaries on all of our accounts, or would you assign an adult you trust who will manage inheritance for them until they become adults?
This is a really good question. Okay, because it comes up all the time. And when you do your estate planning, you're always going to leave your assets to your children. If they're minors, then we get into another discussion, which I'll mention here in a second. But the old putting someone else as the beneficiary that will then provide for your kids, I do not like at all, because you're legally giving it to that person. And then they are only morally obligated to give it to your children. And in 25 years of doing this stuff, there's one thing I can tell you that's true. Money makes people act weird. So you might think, oh, my best friend, she's going to take care of everything. I got no worries. and then some shoe drops or who knows what, and people get weird. So never leave someone else as beneficiary unless it's, you know, your sister, your brother, a loved one, maybe even not then. But really the way to do it would be to consider doing, well, let me say it this way. You have two options. In your wills, you're going to leave your assets to your children. And in every standard will that we do in the legal plan, and probably most attorneys, there is a provision that we call a postponement of possession provision. It basically says if the beneficiary is under the age of 21, those assets are going to be held until they reach 21. And that's it. But then at 21, they're going to get it all. So you do have that protection to 21 if you've got small children, if you've got teenagers. But, you know, a 21-year-old might not really know what they're doing either. So we don't want the 21-year-old to get the money and go down to the Hard Rock or somewhere else. So what you really want to do to protect your children is the best plan. It's the plan that I've had since my kids were born and Liz has had, and the plan that you should have, which is what we call our complex wills. And within the wills, we create trusts for your children. Now, even though I'm using the same word trust, this is a totally different concept, different animal from the revocable living trust that Liz mentioned earlier. This is trust for children created in your will. They're what we call testamentary trusts because they don't exist now. They only come into being after you're gone, and then only if your kids are still younger. So it's pure contingency planning. But what it is if the time comes to pass and the kids are younger and they receive the assets, those assets are not going to be held for them in these trusts until their older ages. There's no magic to this, but our benchmark is we stagger it, a third at 25, a second third at 30, the balance at 35. So if the 25-year-old blows the first distribution, there's still two more in there. There's no magic to that. You could have whatever ages you want, and they're fluid. As your kids get older, you might say, oh, these 20-year-olds are the most responsible kids in the world. I got no worries. And we scrap the whole trust thing. Or the opposite. They don't have a clue. Let's up those ages to 50. So it goes both ways there. But that's a wonderful plan because now you're putting someone else, a loved one, in charge of the money, but legally it's held for the children. So what you have is your trustee, your brother, your sister, your loved one can dole out the money if the kid needs it. The kid turns 16, we want to get him a car. He needs new clothes for school. He needs extracurricular stuff. He's ready for college. We got to pay for college. It can be used for all of the above, but that's at the discretion of your trustee. And that's how we protect the kids from themselves, preserve the inheritance, and all that good stuff. So I hope I answered that question fully.
Yeah.
But that's how we handle that. Yes.
Yeah. The next one is, do you need a ladybird deed if you're already on the deed and mortgage of the home in Florida? And is the deed still beneficiary to the caregiver if the property is upside down?
Good question. If you have an upside down property, we are not going to ladybird that because you're leaving a burden then to the next generation. So, I mean, there used to be the upside down properties left and right, you know, when the whole bubble crashed, but now that real estate is where it is, especially here in Florida, we don't encounter that too much. So if you have property with even a little bit of equity in it, if you're on the property, that's great. But the ladybirding is an estate planning technique. It's just a way for you to take your property and arrange it to go how you want, like this, and avoid probate after you're gone. So it doesn't really have anything to do with your mortgage situation or anything else. But again, if you're upside down, that's just a different story. That's all.
Okay, the next question is, could there be one sibling as the power of attorney and another sibling as a healthcare surrogate, or does it need to be the same person?
Another great question. They're separate documents, so they can be separate people, right? So yes, you could have one sibling here is the financial guru, and then the other one is the nurse or the healthcare person. Absolutely. And remember, we encourage a primary and a backup, so you can flip-flop, put whatever you want across the different documents.
How much would it cost to have the documents processed?
Well, that's a question that's not that easy to answer, in the sense of, well, the answer is it depends. That's the old attorney answer. In this case, it's true though. It depends on which documents you want. If you're doing a trust package, it's more expensive than if you're doing a will package. If you're doing, the Ladybird deed is an add-on, all these different things. But what I can tell you is the pricing we do with Preferred Legal, which is heavily discounted from what you'll find on the street. So for example, a trust package, which is a living trust and all the other documents Liz brought up, the power of attorney, the healthcare, you get a will that comes with it. There's a deed to put your property into the trust, the whole 9 yards of a trust package. On the street, $2,000 to $3,000. Through Preferred Legal, your will is included, no charge for your will. And then we do the remaining trust package for you for $250 of additional cost. For the power of attorney, healthcare, living will documents, those decision-making docs, we do those under the legal plan for an additional cost of $150. To do a Ladybird deed for you, or any type of deed under the legal plan, it's a cost of $100. Those are just some of the co-pays, if you want to call them that, or sort of add-ons with our plan. And when you call in, as Liz said, she'll go through everything with you. So we don't just push documents on people. We tell you exactly what you need, and then we help you get that done. So the last thing I'll mention here, because I've seen it over all these years, is estate planning attorneys on the street. They really love to push trust packages on clients. And look, if you're a young couple or a young person, you don't need a trust. Avoiding probate is not the priority at this stage of your life. That's to be dealt with down the road. But I see that these attorneys push trust packages on young people when they don't really need it. And it's easy to understand why. They could charge 5 times the fees for a trust package versus a will package or something like that. It's a little bit of a pet peeve of mine, because people come to me with these trusts that they did a decade ago. And I say, why do you have trusts? And then I see that their trusts are unfunded. And this is an important point. So you do a trust, you sign the document, you put it away, and you think it's done. No, to avoid probate, you have to retitle every single asset into the name of your trust. So the disservice that these attorneys are doing is they do a trust package for you, but they don't emphasize to you that for the rest of your life, any property you acquire, any account you open must be in the name of your trust, or there has to be probate. So inevitably, these people have done trusts. They leave one account in their individual name. They forgot. Now you have to have a probate, and you've lost the whole advantage of why you did it in the first place. So our approach at Preferred Legal, again, is not to push expensive documents on people or things you don't need. It's to go through your exact situation and help you very specifically that way. So I think that everyone would like that.
Okay. The next question is, if you're on a savings checking account with an aging parent, do you still need to be named as the beneficiary on the account?
No, good question. If it's a joint account, meaning that you, Joyce, can go to the bank and withdraw the money on your own and they won't give you trouble, that's fine, because the joint account will go to the survivor on the first death. So you might just want to check that with the bank, that you're not just a signer, that it's a truly joint account. And this is a good point. Everybody listening, you need to check with the banks, because the banks will screw you every day of the week. They are awful with this end of life stuff. If you don't have it exact, we want probate. We want probate. That's all the bank will tell you. Wait, there's only $500 in the account. It's going to cost me $5,000 to do probate. We want probate. We want probate. They don't care. They are like robots. I hate the banks if you haven't noticed. So do your diligence with the banks or they will not help you. Very important point.
There was someone that had additional questions about children with developmental disabilities and the guardianship process as those children approach adulthood. Are there relative pros and cons of special needs trusts versus ABLE accounts?
Yep. So the ABLE account is a newer thing here in Florida that is definitely viable, but we're talking about maybe two different things. So when your child is going to turn 18, that's when we look at either guardianship of an adult disabled child or perhaps the ABLE sort of point of view. The special needs trust is more for when you pass. And this is a good point. We haven't mentioned it yet, but if you have a special needs child, you don't want to just leave them assets in their name when the time comes, because it could jeopardize their ability to get governmental assistance that they're entitled to and are already receiving. We never want to mess with their ability to get governmental assistance. Very strict. That's when you need to leave assets to that beneficiary in the form of a special needs trust, which is just language written out in your will or your trust, if that's what you do. And it's just pages and pages of very specific language to very explicitly say that this special needs trust is purely supplemental. It is not a primary source of assets or income. Thus, it is not to be counted for purposes of this governmental assistance. So all of the above, if you have a disabled child, you should look at. And again, it's something we can help or an attorney can help you do.
Okay. The next one is, can a power of attorney be set up but not enforced unless the parent becomes incapacitated?
I was waiting for this question. Thank you, Carrie. It's a great question. And the answer is, in Florida, you cannot have what we call a springing power of attorney. In other words, the power of attorney cannot spring into action only when the person is incapacitated. So no, it goes into effect the moment you sign it, and it continues through incapacity. That's how it works in Florida. And the way around that, because you are giving someone a lot of ability and power over you, is you sign the document, you put it away, you don't give it to the person, and you tell them, if something happens to me, if I'm in an accident, anything, I lose my marbles, God forbid, there's very important documents that you need to find, and here's where they are. And that way the person gets their hands on it only when the time comes. So that's our little workaround there.
Okay. Can someone protest a power of attorney or living will if we did not have one in place before a stroke?
Well, anybody can do anything, that number one, but you need to be of sound mind to execute the document. So if somebody wanted to challenge that and say, this person was not of sound mind when they executed that document, you could do that. Unfortunately, that is a legal action that would require you to get a lawyer, pay a filing fee to the court, etc. And then it goes before a judge, and the judge is God in the courtroom, and we never know what a judge might say. So those types of cause of actions are difficult because they're so subjective. They're not objective. So that whole thing it's tough. And any of this end of life stuff where there might be questions is tough because you have to deal with that type of action. You know, so it'll depend, I guess, on how egregious it is. We're talking, but people can sign documents even though they have a condition if they have what we call a lucid moment. You catch them on a good day. So all that stuff, signing documents, capacity is tough to analyze, I guess is a way to put it. You just have to deal with it as it comes and see what that specific scenario is saying.
All these documents that you've gone over, can they be completed via Zoom or do they need to be in person?
No, the documents, when you're a member of the plan, your first step is just to call in and you'll have a phone consult with either myself or Elizabeth, probably Liz. And Liz goes over everything with you, from A to Z, right? And then when we prepare the docs, yes, we mail them to you for signing at your own convenience, but you need the witnesses and the notary to get it done is all. If you can manage that, no big deal. Once you get them done, they're done. So yes, we do it remotely in that fashion.
I have 8 adult children. Can you do family plans or do they have to be individual? Did he specify which plan that we're talking about though?
No, this is a good question. So the legal plan is for you, your spouse, and people in your household. But we oftentimes, probably more often than not, help members with their loved ones' affairs. Usually it's elderly parents. Sometimes it's children as well. So the answer is yes, if you're a member, we can help anybody in the family sort of get this stuff done. And we do it at the discounted rates. So it's a nice service in terms of that.
I'm a caregiver of 96-year-old father of sound mind and body. Discuss the need for these documents, but will not sign. I'm taking his father will not sign the documents. He feels they're not necessary. He's an only other child. My stepbrother is sole caregiver for his own mom living in another county in Florida. His mom has progressive dementia. If my dad needs to go to the hospital, what rights do I have for his care?
That we need to talk. That's your dad needs to come around here because not only it's also a step situation with stepchildren. This is very complex or can be, because the law, which is what you're talking about, if you don't have any documents, the law takes over and the law does not recognize step. So who's this, Rebecca? Yeah, we need to have a convo, maybe a 3-way with your dad, and maybe I could talk some sense to him because these documents are very necessary.
Okay. The next question is, I only have one child who is an adult now. I've wanted to put her name on the house so it will go to her. I've been told to get a quitclaim deed or put the house in trust to her. What is the best way to do this?
This is a great question because people will mess this up all the time. You never, ever want to add your child to your deed. Like just make them a part owner of the property. And this is a tax thing. Let me try to explain it quickly. So let's say you bought your property for 100 grand. Now it's worth 200 grand. If you add your child to the existing deed or put them on a deed to make them an owner now, their basis in the property when they go to sell it later in life is the same as yours. So it's that same 100 grand. Now you pass away, the kid gets the property, which is great directly, but now they go to sell it for the 200 grand. They got $100,000 capital gain that they're going to pay tax on. Versus if we ladybird it, or you do it in a rev trust, or even in your will, if they received a property from you upon death, when you get real estate upon death, you get a stepped up tax basis to the value at the date of death. So now your basis, if you get it from ladybird deed, becomes the 200. Now you sell it for the 200, zero gain, zero tax. You wiped out all that appreciation. So don't ever put your kid on your deed. Do it in the format of a ladybird and you're good.
Going back to the ladybird, I did not hear the answer about whether you need this if someone else is on the deed already.
Okay, another good question. And this is also where we have to be very specific. So if you own the property with the other person, you must look at your deed and see that it has the following magic phrase: as joint tenants with rights of survivorship. If it has that magic phrase, then you're good. If something happens to one of you, it will go automatically to the survivor. But if you don't see that phrase, the exact opposite. When you pass, your half will go through your estate. Big difference. So if you own the property with someone else, let's get a look at the deed. And if it doesn't have right of survivorship, we just do a new quitclaim deed to add that right of survivorship. That's how you handle it when you have multiple people on the property. Last thing there is, if the property's owned by husband and wife, you don't need to see that phrase. There is a presumption of right of survivorship between husband and wife. So that's the only place where it's presumed.
Okay, the next question is, can you have a beneficiary living abroad who is not a US citizen? Do they have to come to the US to claim or retrieve the benefits?
The answer is yes to both questions. Yes, you can, and yes, they will come here, or they must come here.
How do you make sure your will is honored after your death if you have concerns about the people enforcing it? Can you keep it on file somewhere? And how will they know when you die?
You're trusting your loved ones to carry out your wishes. So whoever you're naming as your executor or personal representative of your will, that's the person that needs to know where it is, so they can get their hands on it. And there is some trust involved there that they're going to file it, administer it, uphold it, all those good things. If you're worried about that, then the other option is what you should do that Liz had pointed out, which is beneficiarying all of your assets, because that's set in stone. That's going to go that way. And then ladybirding your properties, and then that is set and going to go that way. And then you leave everyone else out of it that way.
Are you able to review documents prepared by other lawyers?
Of course, that's part of the legal plan, is free review of legal documents. No maximum, as many as you got, we'll take a look at with you. And I love to review estate planning documents from other attorneys.
Is it true you don't need to add IRAs to an irrevocable trust because it already has beneficiaries listed for easy transfer?
That sounds like a law school question. The answer is yes, you're correct. The beneficiary controls the asset. So if you have a trust, here's your thumb. Single asset, either name of the trust or has a beneficiary on it. Either one is fine. It will allow the asset to go direct.
If you have a power of attorney, can the bank still insist on probate?
So let's be clear here, because this stuff is confusing. Power of attorney only exists during the person's time. So the moment your person passes, there goes the power of attorney. Now we talk about end of life. Is there a beneficiary? Is there a will? Is there a trust? Yada, yada. So yes, even though you're POA, if the person passes and they haven't put you on the account, of course, it's going to require probate. And remember, don't ever think the bank will give you the benefit of the doubt. Never will that happen.
I got married after I bought a house. Do I need to put my husband on the ladybird deed?
Happens all the time. It's going to require a conversation with the individual in the sense of, if you add your husband to the house now, you're setting it up so that when the time comes, it will go to the survivor of the two of you, but you're also giving up half your interest in the home. And whether you want to do that or not, that's reserved for a conversation, I suppose. You could do a ladybird deed in your own name, meaning you keep all the control in favor of your spouse after you're gone. And then they only get it after you're gone. Or you make it a joint ownership and then do a ladybird in both names with someone else as the beneficiary that way. It just depends on the marriage and what page both spouses are on in that sense.
Do you have any suggestions for children currently serving as caregivers for their parents, but their parents are unwilling to take care of these things?
They got to do it. I mean, it's just whatever you got to do to get them to see the light is what you're going to do. Otherwise, you're facing guardianship. So maybe you say it to them that way. Look, either you help me sign these documents, or I'm going to have to spend thousands of dollars to care for you. I mean, it's that simple. So people got to get over this fear of these documents. I don't want to deal with this end of life. Come on, you know, I'll say this, that would be the norm. You know, the old statistic was 90% of Floridians do not have a will. That number has changed, not that much, but a little bit since the pandemic. The pandemic had one good thing. It made everybody face their own mortality. So yes, we're all going to pass away at some point. You must do these documents to make it easy on your family, your loved ones, etc. There's no harm in them. So if they're going to refuse, you just got to keep working on them till they come around. And that's why I say sometimes, you know, get them on the horn with me or with Liz, and we'll try to talk sense to them. Again, because this is not a big deal. It's part of life. And that's what people have to realize.
Can an existing power of attorney be changed?
Yes, of course, you can renounce or cancel an existing power of attorney. Really, what you have to do is write revoke and sign at the top of it, and then give it out to all your third parties so they know that this person, you know, that's no longer applicable. And then you would just do a new one in favor of the new person's name.
What is the difference between ordinary and durable power of attorneys?
So in the context of everything we've been talking about today, you would only do a durable power of attorney. That is the estate planning document. An ordinary power of attorney may be something we call a limited power of attorney. Might be for a specific purpose. Like, I'm closing on a real estate transaction, but I'm going to be out of the country, so I want to appoint this person to sign all the papers for me. That's a limited power of attorney or an ordinary power of attorney. But in terms of all the estate planning stuff, it's always durable. And durable meaning it goes on in case of incapacity.
So someone says, I have a power of attorney and living will for parents on his name. I called the banks to get my name on the accounts, and they told me I don't need my name since they have the documents. Is this true?
What do you think? Should we listen to the banks here? What do we think? The answer is heck no. No, you're talking to a teller at the bank giving legal advice. Are you kidding me? No, you need to go to the bank in person, use the power of attorney to add you as a beneficiary, or what they call POD, payable on death at the banks. Use it to add you as the POD to the account, because it's two different things. Yes, you can act on the account with the POA, but the moment the person passes, the POA is done. And then what's the bank going to say to you? Probate, 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 unless you're named as the beneficiary. So that's how you use it, like that.
Okay, so we have 3 more questions. both parents are living, one parent has early dementia and hasn't accepted the diagnosis. What do you do if the parent of sound mind dies before anything is finalized? Like, how do you manage the parent with dementia now that you are left to care for them, but the parent doesn't think they need the help?
You know, you just be there for them any way you can. If both parents are living, what you want to make sure of from an end of life perspective is that all the assets are husband and wife. As long as everything is husband and wife, if the first parent with dementia is not being cooperative, doesn't want to deal with it, you know, from a caregiver standpoint, it's a problem because you need these documents to be able to make decisions. But maybe from an end of life standpoint, it's not as big of a problem if the person passes, because if everything's husband and wife, it'll just go over to the surviving spouse on the first death. And then maybe you can deal with the surviving spouse. They're more reasonable, that you could do some documents and then figure out what's going to happen after they're both gone. But again, you know, maybe you explain these decision-making documents in a way that it doesn't sound like they need help, that it's just something that's good to have. You know your parent better than we do, so you got to get creative. Again, the bottom line is they have to sign these documents. There really is no alternative, or you're going to have potential issues. So however you explain it, you know, maybe you just stick it in front of their face with a pen, you know, whatever you do, you do what you have to do, I guess, is the best way to put it.
Okay, second to last question. I have land and wanted to invest in a multifamily housing project to make an income. I wanted it to be joined with my adult children after I'm gone. Is there a way to protect the land while living and after I am gone?
Yes, that would be with the ladybird deed or a will or a trust or any of the estate planning techniques where you can indicate how that land would be handled.
And then our last question for the webinar. When you have employees sign up for the preferred legal plan, is the estate planning done only for the UF member, or can the employee call in to get estate planning done for other family members?
Yeah, we addressed it earlier, and the answer is absolutely yes. We oftentimes are helping members with their loved ones' affairs, elderly parents' affairs, because guess what? It's your problem, and that's the way we look at it. So we will help you with it.
Okay, well, thank you so much, Elizabeth and Brian, for the valuable information shared with us today. Before you all leave, I dropped a link in the chat to a survey. If you could please take a couple of minutes. The survey shouldn't take longer than 4 minutes to complete. The information that you share with us helps us determine what programmings we might want to host in the future. Anything else you might want to add, Brian or Elizabeth, before we head out?
You know, I guess we could say, if I'll give our email out to the legal plan. If anybody has any follow-up questions, trying to clarify a point, something we explained that you don't understand, anything at all, we're happy to receive those and answer some more questions that way. And that would be to send that to info, I-N-F-O, info at preferredlegal.com.
Okay, perfect. Well, thank you so much again, Brian and Elizabeth, and thank you everybody else for joining us today.
Thank you for having us.
Appreciate it all here.
Thanks, everyone. Thanks, Patricia.
Thank you.